Here, ma'am. You are Michelle Lee Cormier, and Ms. Cormier is charged with a first-degree felony offense of murder in cause number 25 DCCR 0153. Mr. Radford has filed, there's a motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder?
Judge, if I may, the common law has established that murder is when someone intentionally and knowingly causes the death.
Okay, but the statute is what we're going to go by.
Yes, ma'am.
Okay.
But I don't think it was the intention of the legislature to remove the requisite mens rea,
What makes you think that?
because the common law going back 1,000 years has required murder to be intentionally and knowingly.
But they've added
Right.
section B4, which it's a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B, blah, 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 that's fentanyl, that's what the allegation is. And so it actually has the mens rea of knowingly deliver. I mean, it reads straight from the statute, so I'm going to deny that motion to quash.
Can I
Sure.
just make a brief argument?
Yeah.
Under this indictment, under the way that it's pled, if a doctor gives a patient fentanyl and that patient dies, then that doctor can be charged with murder even though he did not intentionally or knowingly.
Well, there's an exception. The next C, except as provided, well, where was it? I saw this. It is a defense to the prosecution under section B4, which is our section that the actor's conduct in manufacturing or delivering was authorized under Chapter 481 Health and Safety Code or state or federal law, which I think would be the medical purposes. So there's an exception.
Is it my understanding then, is the court of the opinion that the state must prove that my client knowingly delivered fentanyl to an individual?
That's what the law says, and that's what the indictment says.
I-
Then and there knowingly deliver a controlled substance, namely fentanyl, and that Shelby Irvin died as a result of ingestion.
This moment right here is where the entire legal foundation of the case gets tested. The defense argues that the indictment fails to allege the correct mental state required for murder, but the judge isn't buying it. She points directly to the statute, emphasizing that knowingly delivering fentanyl is enough to support the charge, especially when the substance allegedly caused someone's death. Notice how sharply she shuts down the hypothetical about doctors and medical prescriptions. She's signaling something important. This courtroom isn't dealing in abstractions. It's dealing in facts, statutes, and consequences. What do you think? Was the judge right to deny the motion?
Inhaling that into her body. So
that it's the opinion of the court that Ms. Cormier must have the requisite knowledge that she was giving her fentanyl?
I think that's.
I think
Go
what
ahead.
Mr. Radford's trying to do is box the court in here.
I'm not gonna.
My interpretation of the statute is just knowingly deliver a controlled substance. And that controlled substance, if it contains fentanyl, is enough for her to be guilty of this offense. If it contains fentanyl and causes the death of a person, then that gets us to murder.
Well, I think that's going to be another whole question because it's specific that
It says knowingly to.
knowingly deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I don't think that's, I'm not going to make that decision. That's not a,
Right.
I mean, that's just an element of the offense. So
I
the
would-
motion to quash is denied.
Yes, ma'am. I would submit that the statute is unconstitutional as drafted.
Okay. I'm not going to find the statute.
I understand.
I'm going to follow it as written.
Yes, ma'am.
All right, so that's denied. Hold on just a second. Then there's additionally, I don't see an order on that motion to quash.
I can.
I got one.
Okay.
So
So
that's,
that's, oh, thank you.
then in addition, okay, I'm just gonna set that right there for now. There's the order. Okay, Mr. Radford has also filed a motion to reduce the bond, which is currently, hold on a second, let me get to all that stuff.
$500,000.
Oh, you filed an application for it to seek reduction. Currently set at 500,000, okay. Or do you plan on calling your
ma'am.
client? Ma'am, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
For the purposes of the hearing, this hearing only, we call Michelle Cormier on the issue of bond reduction. Can you state your name?
Just so you know, once she's under, I don't let anybody go far, but if she's under oath, and I am allowed to take into consideration some of the underlying facts of the case.
Yes, ma'am.
We won't go far, but just don't want you to think that can't go there at all.
Yes, ma'am. I
Okay.
understand. Can you state your name for the record?
Michelle Lee Cormier.
And you are the defendant in
We've now entered a completely different phase of the hearing, the fight over bond. Watch how the tone shifts. The defense tries to humanize the defendant, local ties, family support, willingness to comply with conditions. But the judge immediately reminds everyone that when a defendant is under oath, the underlying facts of the case can be considered. That's critical. This isn't just about whether she can afford bond. It's about evaluating risk, history, and what the alleged conduct suggests about future danger. As the defendant confirms her past convictions and living situation, ask yourself, should bond be lowered in a case involving a death? Or is the judge right to proceed cautiously?
this case, is this correct?
Yes, sir.
And your bond is currently set at $500,000, is that correct?
Yes, sir.
Can you afford a $500,000 bond?
No, sir.
Do you have assets in your name that you could liquidate to make a bond?
My family does.
Your family
Yes.
can help you? Have you talked to your family about possibly helping you with the bond?
Yes, sir.
And how much, what kind of bond do you think your family can come up with?
100,000 or less.
100.
That's what all of them have told me.
100,000, you think they can make a $100,000 bond? Would it assist your case in the presentation of your defense if you were bonded out and could assist me in working on your case?
Yes, sir.
Where were you born?
I was born in Beaumont, Texas.
Okay, have you lived here how long?
I've been back down in this area since I was 13 years old, so.
So you pretty much lived here your whole life?
Yes, sir.
And you have family in this area?
Yes, sir. Jasper area, my aunt here in Beaumont,
Where would you live if you made bond?
the Golden Triangle, Beaumont, where I'm Butter.
Who would you live with?
My aunt, my 83-year-old aunt that comes and sees me, or my son and his grandma in Butter. My aunt lives here in Beaumont, off of Major Drive.
If the court set conditions of your bond, including a GPS monitor and random drug testing, would you agree with that?
Yes, sir, I sure will.
What is your criminal history? Have you been to TDC before?
Yes, sir, I went for early rehabilitation back in 2013.
How much time did you serve?
I made my first parole, and I served 2.5 on that 10 because they sent me to safety. And I successfully came off of parole July the 11th of 2023.
That's a witness.
I want to know, I think it's probably in this reply.
Here comes one of the most explosive points in the entire hearing. The judge confronts the defendant with the core allegation that she smuggled drugs into custody and provided them to another inmate who later died. Immediately, the defense jumps in, objecting to anything that could force her into incriminating herself. The prosecutor pushes for answers, the defense pushes back, and the judge tries to keep the balance. This is where hearings get dangerous for defendants. One wrong admission can become evidence at trial. What would you do in this situation? Stay silent or speak up to defend yourself.
What was Ms. Cormier in custody for
Or theft, if I'm not mistaken, Judge.
when this happened?
Yes,
Okay.
ma'am.
So the allegations here are that you were in custody for theft,
Can I rephrase that?
No,
Okay.
just
Okay.
answer her
Yes,
question.
ma'am.
in custody, smuggled in some drugs of some type in your vagina that you gave to someone else that the allegation is led to her death that had fentanyl in it. Am I correct?
That's it in a nutshell, Judge.
All right, go ahead, Mr. Coleman.
And you don't disagree with the judge's assessment that you in fact smuggled fentanyl into the jail?
I'm going to object to that. I think you said the allegations are what he's trying to do now is bind her into a confession.
I'll move on, Judge.
Thank you.
While you were in jail, did you provide a controlled substance or substances to other fellow inmates?
Again, Judge, I'm going to object. that is not relevant at this time.
I'll move on, Judge.
Thank you.
Where did you get those drugs?
I'm going to object at this time, Your Honor, to that.
I think any of those are going to go to her Fifth Amendment right against self-incrimination,
Yes,
Mr.
ma'am. One last
Clement.
question. When you were arrested on the theft offense back in November of 2024, did you have a pending felony drug case in Orange County? Had you been arrested for methamphetamine possession in Orange County?
Yes, ma'am. I mean, yes, sir.
That's all I asked.
What's the status of that case? Do we
Still
know?
pending as far as I know.
Okay.
I don't think it's been filed. But if it's orange, it could
They're
take-
waiting on
it could take
drug
years.
testing. Okay, anything else?
No, ma'am.
No, ma'am.
All right, based on the criteria under 17.15, the information that I have, the nature of the offense, I'm going to deny the petition or the request for a reduction in bond. I think 500,000 is adequate based on the nature of all of those matters. All right, anything else then on this case?
No, ma'am.
What a hearing. After reviewing the arguments, the defendant's history, and the serious nature of the allegations, the judge ultimately denies the bond reduction, keeping it at $500,000. From the motion to quash the indictment to the tense back and forth about smuggling accusations and prior charges, this case continues to raise difficult questions about responsibility, intent, and the dangers of fentanyl in correctional facilities. As it stands, the charge moves forward, the bond remains high, and the courtroom tension is far from over. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.